So here we go, Mrs. Champion, the floor is yours.
Thank you. Can you hear me? Yeah?
Yes.
Okay. All right, so I will pick up where Mr. Malou left off, just finishing up due process. Including the grounds laid out by Mr. Malou, Colombia's, one of the issues here is Colombia shifting positions on the basis for the asset forfeiture proceedings. Colombian authorities did not seem to take Mr. Lopez's kidnapping complaint filed in 2014 very seriously. Can you go to the slide? Oh, okay. It sat on the shelf for 2 years until it was suddenly revived and used as a basis to seize the Meritage project. As you will see when slide 96 is pulled up, Colombia tries to claim here that the asset forfeiture proceedings were never, that's the word they use, based on the kidnapping story. That's what they say in their counter memorial, their post-hearing brief. In the precautionary measures resolution, Ms. Ardila writes, the reasonable grounds are supported by the evidence included in the file in which show that the assets identified with the particular lot numbers were acquired through punishable conduct, such as kidnapping, threats, and personal misrepresentations, among others. It further refers to the statements of Mr. Lopez and determining whether they are true or not. The court decisions also talk about the kidnapping. If we go to the next slide, or no, you're right, 98. The asset forfeiture court and the appellate decision on Corfi Colombiana's control of legality petition also talk about the kidnapping and Mr. Lopez's statements. So to say that the kidnapping story was not a basis for the asset forfeiture proceedings is just not supported by the record. The problem is that Colombia knows that story is false. In their own opening, they noted that per the information provided by the FBI, Ms. Ardila was already aware of the divergent narratives behind Sebastian Lopez's alleged kidnapping. A prominent Colombian prosecutor, Claudia Carrasquilla, the former director of the Organized Crime Unit in the Attorney General's office, stated on television that the kidnapping story was a fraud. But that's not what happened here. As Mr. Malou has already explained, claimant's expert, Dr. Martinez, sets forth what the state can do when the assets it seeks to move against are in the hands of third parties acting in good faith. It can move down the chain of title and attach the assets or equivalent assets or proceeds of the alleged wrongdoers. Colombia sent us this demonstration, but that's not whose assets Colombia went after. They went after those of the claimants here, not the assets of the alleged wrongdoers. Because Colombia acted arbitrarily by premising the asset forfeiture proceedings on a known lie, and disproportionately by not pursuing the stated public purpose of these measures, they violated the fair and equitable treatment provisions provided in Article 10.5 of the TPA. The tribunal in EDF v. Romania sets forth factors to consider in determining what is arbitrary. These come from a noted expert on this, Professor Christoph Schur, who has identified these factors as a measure that inflicts damage on the investor without serving any apparent legitimate purpose. That's what happened here. Again, the damage was inflicted on the claimants, on the investors. It served no purpose to inflict the damage on them. They were not the alleged wrongdoers. A measure that is not based on legal standards, but on discretion, prejudice, or personal preference. Again, here, as Mr. Malou covered, Ms. Ardila's discretion appeared to govern the imposition of the precautionary measures entirely. She said it was entirely her decision. A measure taken for reasons that are different from those put forward by the decision maker. We'll get to that. I think there's a strong argument here that this was actually motivated by a corrupt scheme that Ms. Ardila became a part of. And finally, a measure taken in willful disregard of due process and proper procedure. Mr. Malou has already identified some of the issues relevant to that. On this slide, you just see some cases that, that talk about the principle of proportionality. What is proportionality? It looks at the state's goal versus the claimant's interests and the nature of the conduct being censored. Again, Colombia alleges that it's going after illicit assets, assets derived from criminal activity, but that's not what it's actually done here. It could have traced back in the chain of title, gone after the wrongdoer's assets, the payment rights. They haven't done that. Instead, they've gone after the claimant's investment. I'm going to revisit the timeline. This will look familiar. We used a similar slide in our opening. We've added a few things that emerged during the hearing in this case. But the tribunal will recall that Lopez filed his kidnapping complaint in 2014 with the organized crime unit. And at that time, he is threatening Mr. Seda just with bad publicity, right? He says, if you don't pay me, don't make a payoff, I'm going to tell everybody that I actually own the land and that, they shouldn't buy in your project. The organized crime unit refers the complaint to the asset forfeiture unit. It's assigned to prosecutor number 37, that's Ms. Tobar. Ms. Tobar appears to have requested that the judicial police do some investigation, but the case remained dormant for nearly 2 years. That changes all of a sudden in April of 2016. We submit it's not a coincidence that on the 7th of April, Mr. Lopez, represented by a new lawyer, Mr. Mosquera, contacts Mr. Seda claiming that he is the rightful owner, that Mr. Lopez is the rightful owner of the Meritage property, and demanding a meeting in DC, of all places, to explore an alternative resolution. Colombia would have you believe it's a coincidence that the very next day, Ms. Malagón, the head of the asset forfeiture unit, opens a new case based on Mr. Lopez's complaint and assigns it to prosecutor number 44, Ms. Ardila. Nowhere in the resolution opening this new investigation does Malagón acknowledge the pre-existing investigation. It's simply ignored, even though from the day this investigation is opened and assigned to Ms. Ardila, she has in her hands a memo that Ms. Tobar had requested as part of her prior investigation. That's the chart that I extensively cross-examined Ms. Ardila about, and as you will recall, and as Mr. Malou did mention, she tied herself in knots trying to explain why she went after the Meritage and not any of the properties in that chart. And every rationale she offered simply did not hold water, whether it was the time period, whether it was the fact that the lots had undergone consolidation and re-subdivision, whether it was the fact that lot numbers became extinct as a result of that process. That's all true for the Meritage lot as well. None of the explanations she tried to give for why she focused immediately on the Meritage held any water at all. During the same time period that Ms. Ardila receives this memo, Mr. Mosquera is stepping up his extortion demands. He's asking Mr. Seda to confirm a meeting so that they can reach a quote-unquote brokered solution. And he starts to threaten legal proceedings. Mr. Seda is concerned about this threat of legal proceedings. He responds. He offers to meet in Colombia. Mr. Mosquera declines and says, we're proceeding with our defense. That defense turns out to be the tutela that Mr. Lopez filed. And interestingly, in the tutela, Mr. Lopez seeks the same relief that Ms. Ardila ultimately gave him when she imposed precautionary measures. He seeks to enjoin construction and sales of the Meritage project. Well, the asset forfeiture court dismissed the tutela, but as noted, Ms. Ardila later gave him the relief that he wanted. The other concerning thing that happens in this time period is that Mr. Seda is approached by someone claiming to be from the Attorney General's office. If we go to the next slide. In mid-June. This is before Mr. Seda has any clue what's going on inside the Fiscalia. And he's approached by a man outside the Charlie Hotel asking him to pay a 500 million Colombian peso bribe because the Fiscalia is trying to help him. During the same time period, Mr. Seda meets with Mr. Valderrama, another representative of Mr. Lopez, and Mr. Mosquera and Mr. Lopez himself. After Mr. Valderrama shows him pictures of his children in an obviously threatening gesture, Mr. Seda flees the meeting. During these meetings, Mr. Mosquera brags that he has influence over the Attorney General's office, and specifically the Asset Forfeiture Unit and Ms. Malagone and Ms. Ardila in particular. Again, this is while Mr. Seda has no idea what's going on in the Asset Forfeiture Unit. But Mr. Mosquera is saying, I can influence them, and if you don't pay us about 20 million US dollars, that's what I'm going to do, and I'll get the project seized. Mr. Seda flees that meeting. He tells them he's going to report them. Mr. Valderrama immediately sends him conciliatory text messages. I'm so sorry. Let's restart the exchange. All of this is in the record. It's all corroborated by those text messages. He doesn't hear from them for a while. But then all of a sudden, 6 weeks later, in late July, Mr. Valderrama again texts Mr. Seda. He tells him we need to speak urgently. Mr. Seda replies that he's not interested and tells Mr. Valderrama that if he contacts him again, he's going to call the authorities. Mr. Valderrama says, I understand the negotiation chapter is closed. Unknown to Mr. Seda, but apparently not to Mr. Valderrama, just the prior business day, 3 days before, the prior business day, Ms. Ardila has signed the precautionary measures resolution, and she also testified at this hearing that Ms. Malagone was well aware of that resolution too, that it would have been reviewed as part of a regular committee that they have. So Ms. Malagone knows about it, Ms. Ardila knows about it, and it seems that Mr. Mosquera, Mr. Lopez, and Mr. Valderrama know that it's coming too. As Mr. Malou has already covered in detail, Ms. Ardila shows up at the lot on August 3rd. She imposes the precautionary measures. At this point, Mr. Seda is obviously desperate to save his project. He decides to seek help from the U.S. Embassy, and as part of that, he wants to obtain the extortionate monetary demand in writing. So he meets with Mr. Mosquera and Mr. Lopez Venegas again in Miami this time. Mr. Mosquera reiterates his demand for around 18 million US dollars, 56 billion Colombian pesos. And, he even suggests that Mr. Seda can pay that into a fiduciary offshore account and only release it once the precautionary measures are lifted and the asset forfeiture proceeding against the Meritage is dismissed with a finding that Newport is a good faith buyer. Mr. Mosquera apparently feels comfortable that he has the power to make that happen. Again, he brags about his contacts and his influence over Ms. Malagone and Ms. Ardila, and that's the deal he tries to strike with Mr. Seda. That is not a deal that makes sense if he's bluffing. Mr. Seda then does obtain the monetary demand in writing, and he again cuts off contact with these extortionists. And ultimately, he does report this to the Colombian authorities, and the tribunal heard from Mr. Hernandez, who was one of the prosecutors in charge of the ensuing investigation. The accuracy of two explosive reports that appeared in the Colombian newspaper El Espectador in October of 2020. As set forth in those articles, which are C-365 and 366, since December 2016, suspicions on the existence of an alleged cartel made up of corrupt officials within the asset forfeiture unit of the prosecutor's office have been gathering steam. It goes on to describe what this investigation has uncovered thus far, including, again, extortion taking place in asset forfeiture cases involving Ms. Malagone and Ms. Ardila. The Gran Estacion case is mentioned, as is the Supercundi case. In sum, Colombia acted arbitrarily and disproportionately when it initiated the asset forfeiture proceedings in furtherance of a corrupt scheme in breach of the fair and equitable treatment protection in Article 10.5 of the TPA. Again, I think it's important to take a step back. Why did all of this happen? Ms. Ardila claims, Colombia claims, that her investigation was into the assets of Ivan Lopez, that's what differentiated it from the prior investigation, which was based, they say, on the kidnapping complaint. As we've seen, the Colombian courts and prosecutors rely on the kidnapping complaint in this asset forfeiture proceeding too, but that's Colombia's story. So why is an asset forfeiture investigation that's focused on Ivan Lopez's assets She received a list of 47 of them. Why? Why did she zero in on the Meritage? Why? Why not look at those assets, the assets that actually pertain to Mr. Lopez personally, which the Meritage lot never did? I would submit that corruption is the most credible explanation that we have. Colombia itself has endorsed what's called the red flags approach, followed by the tribunal in Spentex. The tribunal should adopt a methodology of starting from red flags, individual indicia of corruption, and connecting the dots to obtain a larger picture. As Colombia argued there, it's practically impossible to prove corruption, so tribunals should use this time-honored methodology. That's the Glencore v. Colombia case. I will now cover how the initiation of the asset forfeiture proceedings was unconnected to any rational policy purpose because of Colombia's failure to target illicit proceeds. I think this has been covered really by the content of slides that we've already covered, so I will just quickly go through it. Again, Colombia claims the purpose of these proceedings is to investigate and sanction members of the Oficina de Envigado, which they allege is a narcotics trafficking cartel. They say that the asset forfeiture laws are used for the pursuit of assets acquired through illicit enrichment. They could have gone after the alleged wrongdoers. They could have gone after Ivan Lopez and his assets. The asset forfeiture law even allows you to seize equivalent assets. If you find that an asset has been gained illicitly, but it's now in the hands of a good faith third party, you can go after equivalent assets that belong to the person that was alleged to have engaged in the wrongdoing. That's not what they did here. They went after the Meritage. Again, this did not meet Colombia's stated policy objectives. Tribunals will look at, factors that tribunals will consider to determine if a state action is arbitrary. And tribunals have said that measures are arbitrary if they are not reasonably related to a rational policy purpose. Again, it's hard to see what rational policy purpose was served by any of this. It's certainly not the one that Colombia identifies. Another way in which Colombia breached the TPA was by failing to assess Newport's good faith. What is the good faith standard under Colombian law? Well, we have a constitutional court judgment from August 2020. And this constitutional court judgment talks about how when someone intends to acquire an asset, it is up to that person to ascertain the legal status of such asset, the asset. It focuses on the asset in order to establish the history and chain of title and tradition, but not to inquire into the history or personal details of the party that transfers the respective assets to him. So again, the diligence is into the asset. Is the asset free of encumbrances, liens, or claims that someone could make against the asset, right? The statute of limitations for those claims in Colombia is 10 years. So that's why when people are acquiring property in Colombia, they will do a title study that looks at the asset for the last 10 years. Dr. Carlos Medellin, again, former Minister of Justice and an expert for claimants in this proceeding, has further explained that what good faith requires is objective and diligent actions aimed at verifying the conditions and possible defects of the asset, right? Objective and diligent actions, not perfection, that's not the standard, or as Colombia seems to require, a completely backwards looking thing that says, well, we found a mistake in your diligence, we think you should have detected this or that, therefore the diligence wasn't sufficient. That seems to be the standard Colombia is applying. It's not the standard. Perfection is not the standard. It requires objective and diligent actions, not perfection. If we look further at that constitutional court judgment, the court explains why the standard cannot be that you have to exhaustively investigate not just the seller of the asset, but everybody going backwards in the chain of title, all the other sellers of this asset ever. I mean, as the court explains, this would make legal trade difficult or impossible. The court explains here that in a scenario such as this, people in legal commerce would be obliged not only to study the title to the assets, but also to perform meticulous investigations into the legal past of the sellers into any legal disputes they may be involved in different jurisdictions, into the investigations and inquiries carried out by the prosecutor's office in which they could be involved, and even into opinions about said sellers in their communities and on social media. Again, the court says this is not required. This is not what is required, and it's commercially impractical and impossible. I'm going to be very brief on these slides because I think the tribunal is fully familiar with the steps that were taken here, the steps of diligence that were taken here. Again, Newport hired one of Colombia's largest and most trusted fiduciaries, Corfi Colombiana. Corfi Colombiana asked that the purchasers at Newport carry out a title search, recommended a respected law firm to do that title search. That was done. The title search came back with a favorable opinion. No encumbrances, no reason that you cannot purchase this property. The title search also included a search of the OFAC and UN lists for mention of the individuals and legal persons appearing on certificates of encumbrance and transfer history. Came up with nothing. One of the lawyers who did that study, Ana Palacio, explains the reason why they do a 10-year search. As I already said, it's because it's tied to the statute of limitations for claims against title. It's 10 years in Colombia. That's why 10 years is the industry standard. They went further than that, though. Despite what this Colombian Constitutional Court decision says, they did do KYC on the seller, right? They did a company study of La Palma, Argentina, came back favorable. Corfi Colombiana, as a regulated financial institution, subject to Colombia's SARLOFT procedures, that's a risk management system for money laundering and terrorism financing, right? So Corfi Colombiana has to have a SARLOFT procedure. It has to be approved by the government. Colombia followed that procedure here. The testimony of their representative, she explains what was done here. SARLOFT was run on not just Newport, but La Palma, the investors. It all came back clean. No reason not to proceed with the project. Now, Mr. Caro on cross expressed basically complete ignorance of Corfi Colombiana's SARLOFT procedures and just didn't seem to think they were relevant to his inquiry about whether their diligence had been adequate. But in fact, claimant's expert, Dr. Martinez, again, one of the drafters of the law, explained that when an entity satisfies the minimum requirements on prudence that the law demands, in this case, Corfi Colombiana complied with the requirements applicable to it as provided by Article 102 of the EOSF, which details the SARLOFT due diligence requirements. By undertaking that due diligence in accordance to the legal system, it can be stated that it has acted in a prudent manner without fault. Corfi Colombiana satisfied its diligence duties, but it went above and beyond. By the way, that's paragraph 73 of his first report. Corfi Colombiana went even further, though. Their outside counsel, Francisco Cintura, who was himself a former vice-fiscal, wrote to the Attorney General's office, wrote to the Asset Forfeiture and Money Laundering Unit, which at that time were a single unit. And he submitted a list of over, this is a 60-page submission, a list of all the names of the owners of the property and the legal representatives of the entities in the chain of title that then appeared in the records, plus La Palma, plus the property. Submitted that list, told the Attorney General's office why they were submitting the list, because they were going to make an investment, because they were going to acquire this property, asked whether there were any active investigations involving any of these persons or entities. The response came back, there's nothing. Again, this went above and beyond. Again, let's look at what Colombia's criticisms are of the diligence that was done here. In their opening statement, they criticized the title study for going back only 10 years, not 20. They claimed that had Otero and Palacio conducted a full investigation, they will see, as we have seen before, and contrary to what the claimants say, that indeed there was Ivan Lopez Venegas appearing as a representative of Sierra Alta, and was indeed, if they had just done a Google search, they would have seen that he's a drug dealer. Well, again, this is exactly what the Constitutional Court has said you do not need to do. But it is also completely backwards looking. Colombia doesn't point to any written rules that say your title study has to be 20 years instead of 10. Nothing, right? It's all just based on, again, we think we found a mistake here. Since you made this mistake, your diligence must not have been adequate. That's exactly what the Constitutional Court said was commercially unworkable. Indeed, Colombia took the position that in order for diligence to be adequate, it would have to go all the way back to the origin of the asset. That's what they said. Again, there's no written rule. That's just what they say would have been needed. Now, the question that has arisen in these proceedings as well is, when did this diligence attach, right? When did Newport become someone who would have been an affected party with property rights in the asset that was seized? The decision of the Superior Court of Bogota that recognized Newport as an affected party relied on the sales purchase agreement, which was executed in November of 2012. Now that is effectively an option contract. It gives Royal Realty, later assigned to Newport, the option to buy the property. One of the requirements is that title come back clean. La Palma has to, title has to come back clean. So, of course, they did, as we've already discussed, they did go out and do their title checks, they did all their other diligence, and then they create the rest of the structures that eventually are set up to carry out the development of the Meritage project. So when did the good faith attach? When was this diligence done? What is the date? The clearest statement in the record comes from, again, Dr. Medellin. And he says, the date of the signing of the commercial trust agreement entered into between Newport and Corfi Colombiana in the year 2013 is determinate. As of that time, the parties to said agreement already had a patrimonial interest over the real property asset. Again, it's not about title. It's about having a patrimonial or pecuniary interest in the asset. It's not about having title to the asset. Therefore, it cannot be demanded of them that they continue engaging in acts of due diligence regarding a transaction that had already taken place. Dr. Wilson Martinez agrees that the relevant time is October 2013. That's when the trusts are set up. That includes the pre-sales trust and the payment trust. And again, this is done in October 2013. After those trusts are created, they start pre-sales, they start promoting the project, they start selling units. Now, there is no duty to revisit diligence. I think an exchange between the president of the tribunal and Colombia's witness makes this very clear. If we just skip ahead to slide 153. The president of the tribunal asked Mr. Reyes, assume I buy a property in Colombia and there is no problem, nothing turns out. I do a due diligence that you would consider sufficient, and 10 years later, I learn that a relative of Escobar was involved in at the origin of the property. Now, does that affect my property rights? Mr. Reyes' answer is unequivocal, absolutely not. The president goes on, okay, if I want to resell the property in the year thereafter, so the new circumstance has arisen, and I want to sell my property, and now it is known that there was at the origin an illicit circumstance, would I be able to sell the property to somebody else? Would that somebody else be a good faith purchaser? Because he would know, wouldn't he? Probably he would know of the illicit origin. Again, the answer is unequivocal, yes, you can sell it. Part of being a good faith buyer is being able to alienate the property, right? If you can't sell the property, that's not much of a property right. The two are connected and inherent. There is no duty to revisit diligence, redo it. But Newport and Corfi Colombiana nonetheless did revisit the diligence when Mr. Lopez first approached Mr. Seda in 2013. As Mr. Seda stated on cross, they re-reviewed all the diligence that had been done. He reported the approach to La Palma, Argentina, the seller. He reported it to Corfi Colombiana. He went on a nationally syndicated radio program to talk about the extortion demand so that the unit buyers would know about it. And they found nothing. There was no evidence that Mr. Lopez owned the property, that he had any ownership right to the property. Corfi Colombiana also revisited the diligence. In the testimony of Ms. Betancourt and slide 151, she sets forth exactly what they did. We verified once again how the business deal had taken place. We verified the title studies. We verified the searches. We looked into La Palma again. We confirmed that there were no issues, none at all. Again, this wasn't required, but it was done anyway. Oh, I apologize. I just want to correct the record. I misstated the date when Mr. Lopez approached Mr. Seda. It was 2014, not 2013. Slide 152. Ms. Betancourt explained that all of the contracts remained in place. There was no grounds to terminate them. After revisiting the diligence, there was no reason to terminate them, and they proceeded with the project. But if that's not enough, again, Mr. Malou already covered this in detail, but other banks and fiduciaries continue to transact in properties where Mr. Lopez Venegas is on title. Apparently, he's not triggering an issue with anybody's diligence. This includes a government-owned fiduciary, Scotiabank Colpatria, another large bank in Colombia, Acción Sociedad Fiduciaria, again, a large fiduciary, and even Banco de Bogotá. Again, they're all buying and selling, developing Mr. Lopez's properties, and apparently their diligence is not turning up any issues. By initiating these asset forfeiture proceedings against the Meritage, arbitrarily and without any rational policy purpose, Colombia breached the fair and equitable treatment protection provided in Article 10.5 of the TPA. We've already talked about the certificate. I'm just going to briefly cover these slides. It created a legitimate investment-backed expectation, right? Mr. Cintura told the Fiscalia exactly why he was requesting this information, because we're going to conduct a transaction in this property, because we want to avoid acquiring any assets that may be involved in active investigations, right? He told them, this is why we're asking you for this information. The head of the unit responded that there were no issues. Mr. Seda testified about the reliance on that certification from the Fiscalia as part of the broader package of diligence that was done. And as, again, a question from the president of the tribunal to Colombia's witness, Mr. Caro. The president asked, that's the part of the document which deals with good faith, and I would like to start with the individuals that are named on page 139. These are individuals identified in Corfi Colombiana's petition. When I look at them, Mr. Arboleda, that's the mango vendor, Mr. Cardona Rodriguez, that's the engineer, Mrs. Munoz and Ms. Rendon Hill, the model. These individuals were named in the list that was part of the petition to the Attorney General's office of August 2013. When you received this petition and you responded to it, those individuals were commented as not listed in the information system. So in other words, I conclude from this that at that time you were not aware that, for example, Mr. Arboleda, who was, according to the respondent's position, a frontman and a former mango vendor, do I understand that correctly, you were not in possession of such information in 2013? Well, Mr. Caro says, I'm not the one to give the answer, but he says the chief of the unit at that time is that person, and that's exactly who provided it. Again, Colombia's own prosecutors confirmed to Mr. Seda that they had a legitimate expectation based on this certification. That expectation was backed up by investment. And by frustrating that legitimate expectation, Colombia breached its obligations to provide fair and equitable treatment under Article 10.5 of the TPA. These cases explain that the touchstone of fair and equitable treatment is the frustration of legitimate expectations backed by investment. That's exactly what happened here. I'll just briefly cover another breach, which is the fact that Colombia's measures, the measures taken here, put claimants' entire portfolio in the line of fire. Colombia knew or should have known this, should have known that all of Royal Realty's business would be put directly in the line of fire. An asset forfeiture proceeding, an unfounded criminal investigation taint the reputation of the affected party. It really goes without saying. It signals that the party is involved in illegal activity or that the party did not conduct adequate diligence, or both. In either scenario, banks, investors, and customers will avoid working with that person. Colombia submits that we have put in no evidence of this. That's simply not true. There's the publicity. There are multiple letters, text messages, agreements in the record, testimony that show that one by one these projects came to a halt, and they came to a halt because of the proceedings against the Meritage. We have Mr. Lopez Montoya's testimony, Mr. Seda's testimony. We have emails from investors who said, we can't go forward. Oh, okay. And there's more in the appendix. We cannot go forward until the Meritage issue is resolved. The purchase agreement for the land for the Tierra Bamba project was revoked, and it specifically states, given the difficulties and the scandal related to Meritage project, we're revoking this. The management contract that Royal Realty was going to enter into with a hotel in Tierra Bamba, also revoked because of the Meritage project. Mr. Seda sets forth in his witness statement how the Meritage seizure affected his other projects. People wouldn't go into business with Royal Realty. They would not buy land with them. They would not enter into deals with them. They could no longer attract investment. All of these projects at various states of development died. They were put into the line of fire by Colombia's actions. Again, Colombia criticizes this evidence. They say it's based on testimony. It's not just based on testimony. You saw some of the documents there. There's more in the appendix. But again, Colombia had the opportunity to cross-examine these witnesses. Colombia's conduct arbitrarily and unreasonably placed claimants' investments in the line of fire in breach of the FET protection in Article 10.5 of the TPA. Colombia also failed to protect claimants' investments from the arbitrary and irrational conduct of officials within the Attorney General's office in breach of its obligation to exercise vigilance pursuant to the FPA protection also provided in Article 10.5 of the TPA. As set forth in this case, Rompetrol versus Romania, in the tribunal's considered view, it is part of the legitimate expectations of a protected investor without in any way trenching upon the sovereign right of the host state to prescribe and enforce its criminal law, that if its interests find themselves caught up in the criminal process either directly or indirectly, means will be sought by the authorities of the host state to avoid any unnecessarily adverse effect on those interests, or at least to minimize or mitigate those adverse effects. Colombia simply did not do that here. In fact, its officials took the path that would cause the most damage to claimants' investment. As the tribunal explained in AMT versus Zaire, the obligation on the state is one of vigilance, right? The state must be vigilant. The obligation incumbent upon Zaire is an obligation of vigilance in the sense that Zaire, as the receiving state of investments made by AMT, an American company, shall take all measures necessary to ensure the full enjoyment and protection and security of its investment and should not be permitted to invoke its own legislation to detract from any such obligation. Colombia cannot simply rely on the fact that it has an asset forfeiture code, that it's purportedly following that code. It has to be vigilant. It has to ensure that the measures it's taking are not unnecessarily inflicting damage. They did not do that here. Finally, and briefly, Colombia has engaged in a sustained and increasingly hostile campaign to tarnish Mr. Seda's reputation, a completely unnecessary campaign. The asset forfeiture proceeding itself did enough damage, but they have not stopped there. Although stating in their pleadings before this tribunal that Mr. Seda was not personally accused of any wrongdoing, Colombia has pivoted 180, and they've launched a retaliatory campaign. And the rest of the claimants have never been charged with the crime, either in Colombia or the U.S. Even though Mr. Seda has been subject to invasive investigations, never been charged with the crime. Never been put on the OFAC list, the UN list, etc. There's simply nothing to back up all of this innuendo. This campaign to tarnish Mr. Seda's reputation amounts to a failure to protect Mr. Seda and his investments from in breach of Colombia's obligation to exercise vigilance pursuant to the full protection and security protections provided by Article 10.5 of the TPA. I will turn it back over to my colleague, Mr. Malou, who will address damages.
Thank you, Ms. Champion. Just what you gentlemen want before lunch, the most technical part of my presentation. So for the next 30 minutes, if you'll bear with me, we will go through why we think Colombia's conduct has caused damage to claimants and the amount of damage that claimants have suffered. The first thing I want to talk about is causation. And the TPA itself in 10.16 deals with causation. It says that what can be claimed here is loss or damage that by reason of or arising out of the breach can be claimed. By reason of or arising out of. And we would submit that all of the damages that I'm going to talk about are by reason of or arising out of. And in particular, there's a question about the non-meritage projects. And I think we've given you enough evidence as to why all of those projects, it doesn't make any sense why the Luxe wouldn't have been finished. It's a 75% done hotel. Financing's in place. Construction contracts are all in place. Why that gets stopped? It gets stopped because the bank pulls the financing. They shut off the tap that they've already approved. There is no other reason why these projects dry up, but for the measures that are at issue here. And as Joseph Charles Lemire versus Ukraine says, if it can be proven that in the normal cause of events, a certain cause will produce a certain effect, it can be safely assumed that a rebuttable presumption of causality between both events exists, and that the first is the proximate cause of the other. And Ms. Champion took you through a lot of this, but here on this slide is some of the evidence that's in the record as to, obviously the Meritage projects was halted, but why the banks pulled the financing, that's covered by the witness statements, but also documents. Other investors withdraw from the Luxe, one of them, Paladin, one of the private equity financiers refused to invest any longer in Luxe, and in some of the development projects where they basically just said, you know, we're not investing with you anymore because we're worried, obviously, that the same thing is going to happen to your other projects that happened to the Meritage. One of the things that Colombia says is, yeah, but nothing happened to the Charlie. The Charlie's still operating. But the Charlie's obviously in a very different situation because it doesn't need third-party financing anymore, right? There's no third-party financing. It's self-sustaining, right? There's no other business partnerships or anything needed. Now, Dr. Hearn says, that's the respondent's expert, they say claimants should have no issues pursuing these other opportunities because they can just sell the projects. They can just sell them, or they can, you know, pursue other projects. But he fundamentally misunderstands the case that Colombia itself is putting forward. He can't sell them. He can't sell these other projects because now he's associated with this illegality. So people are hesitant to buy from him. It's national news, right? So on Colombia's case in this proceeding, selling is going to be difficult. But in any event, I asked him in cross-examination, well, you're saying this. You're saying, you know, he can still develop these other projects. What's stopping him? And, you know, he can still sell them. But have you seen any of the evidence? And he said, and I asked him, you haven't seen the evidence, right? I refer to the Paladin statements, these private equity investors, and he says, I haven't. I haven't looked at the evidence behind those. And I said, for example, C-186, we can pull it up. Do you call seeing this agreement? It was an agreement where they had to terminate one of the contracts because of the Meritage. And he said, I can't recall, honestly, whether I've seen that particular agreement. And then I took him to the statements by the government officials where they're saying, yeah, of course you're going to be affected by these things. And he said, again, can you take me to the statement? And I took him to one of the statements, and he said, I have not seen this document. And I took him through a number of these documents that you've seen today, and he hadn't seen any of them. And then I asked him, and if he was prevented, Mr. Seda and Newport and Royal Property Group, from being able to transact and to sell these projects and do the business that you're saying they could have done, then what would have been your conclusion? And he said, yes, logically, if he is impacted and he can't develop them and he can't also sell them, then I would take a different view that economically those projects must have been impacted then. That's what their expert ultimately said after I took him to all of these documents, and he said, well, if I would have, if that was what happened, if he couldn't sell and he couldn't develop these projects anymore, then I would have taken a different view. So what is that compensation? Well, we start with what is the legal standard, and we all know it's fair market value. No dispute there. Colombia agrees fair market value captures the full reparation owed to claimants. And Dr. Hearn, their expert, says it's the price that a willing buyer would pay a willing seller in the market, in a liquid market, the hypothetical price. He agrees that that's the approach. And then we talk about, well, what is the fair market value? How do you assess fair market value? And there's three ways, I'm sure the tribunal's familiar with them: income-based approach, market-based approach, and an asset-based approach. And the starting point, and I think it's well accepted now, is the income-based approach. And why is that the starting point? It's because it properly captures the value of that investment to the owner, and the owner or controller of the entity is likely to have the detailed information needed to give a realistic assessment of those future cash flows. So that's why you start with an investment-based approach, and that's where all economists in the real world, and I think more so now in investor-state arbitration, generally start. But especially in the context of real estate development, because there aren't a lot of real estate development cases in the investor-state context, so I think it's important to think about, well, in the real estate development context in particular, what do experts do? And so we went to CBRE, who's, again, that's Colombia's expert. CBRE, well-known industry expert, real estate expert, and we found an expert, an assessment that they themselves had done of an undeveloped, completely undeveloped piece of land. You may recall there was some confusion about whether this piece of land was in California or in Mexico. It's in Mexico. But this piece of land there was a valuation done in March 20 of 2018 by the expert that CBRE put up in this particular arbitration. And their completely undeveloped piece of land, they used a discounted cash flow approach to assess the value of the land. They said, what's the highest and best use? Well, the highest and best use is you're going to develop this land. You're going to subdivide it, and you're going to you're going to build a bunch of units, and you're going to sell that finished product. Let's do a discounted cash flow of this land based on that highest and best use of that property. And Ms. Ritwick asked Mr. Mulgari on cross-examination, have you ever done a DCF for an undeveloped project, completely undeveloped? And he confirmed, yes, I have. And when I took Dr. Hearn to this, because he's not an industry expert, I would submit, I talked to him and I asked him, are you familiar with the subdivision development approach that CBRE had taken in this valuation report? And he ultimately said, he looked at it, he read through it, and he goes, the value of the underlying land is then estimated, I'm asking him, estimated through a discounted cash flow analysis with revenues based on the achievable sale price of the finished product. And I asked him, have you ever used this approach to value other assets, undeveloped asset? Have you used this discounted cash flow approach to do this for a piece of land? And he said, yes. So apparently, Dr. Hearn has done so too. And I asked him, do you disagree with an approach of valuing an undeveloped real estate project, completely undeveloped, nothing on the land whatsoever? Are you okay with basically using a DCF approach? Do you have any issue with that? And he said, not as a matter of principle. As a matter of principle, would I disagree with the use of a DCF for undeveloped projects? Not necessarily, because I think there are some circumstances where one could get quite comfortable with, how that project would evolve. So both CBRE and Dr. Hearn are comfortable with using the DCF approach for completely undeveloped land. Now, the Meritage and Luxay are obviously not undeveloped piece of land. We'll get to that. But even for a completely undeveloped piece of land, they're okay with using the DCF approach. They confirmed that at the hearing. And why are sunk costs not okay? Why does that not make sense, especially, I would say, in the real estate development context? Well, first of all, because it doesn't value the know-how, the brand value, the track record, the experience of the folks who are coming to build that property. So you don't just, what I paid for that piece of land is not necessarily what it's worth tomorrow. There's appreciation, obviously, but if I'm bringing some added value, some knowledge, some expertise, I get permitting done, etc. That all has value that you have to give, that you have to account for. And that's the problem with the sunk cost approach. It doesn't give any value to these intangibles, the market knowledge, the consumer insight, the vendor relationships, the hotel management experience, all of the things that the Royal Property Group had. Not anybody can come in and do this. This requires some sophistication, some knowledge that, by the way, obviously the Royal Property Group had, because they had done this before. But Dr. Hearn, despite accepting that the DCF approach would be okay for a completely undeveloped piece of property, he basically confirms that the approach he took was a sunk costs updated at risk-free rate. I asked, is that what you've done? You basically saw sunk costs updated at a risk-free rate? And he said, essentially. And he was resisting the sunk costs terminology. And he said, you could think of it as a replacement, an estimate of the replacement cost. But he confirmed it's sunk costs, risk-free rate, updated. That's not fair market value. Sunk cost, anybody who owns a house knows what I paid for the house 10 years ago is not what it's worth today, hopefully. It could go up or down, but it's not what I paid. That's not the fair market value, even just for a piece of property. Some more on confirming that that's the approach he's taken, just basically a sunk cost approach, a replacement cost. And the reason why he justified this replacement cost approach, what was the reason? I was trying to figure out how could he justify this as an economist. And he said, well, in a perfectly competitive environment, where it's perfectly competitive, that's an economic term of art, then it makes sense. Your sunk cost updated at a risk-free rate is going to be what the thing is worth because it's a perfectly competitive environment. I can go and buy that replacement. If I buy a widget from one person, I can go and buy a widget from someone else for the same price. And I asked him, but that's your assumption, but nothing is perfectly competitive, right? And he said, right, that's right. But that's his assumption. That's the only way you get to a replacement cost theory for fair market value, is if you're assuming a perfectly competitive environment. But he accepts that nothing is perfectly competitive. And I would suggest, especially the real estate development market in Medellin, where one of the main reasons why Mr. Seda went there in the first place was because he saw opportunity. He saw that there wasn't a widget on every corner that you could buy. There wasn't a luxury hotel. There was opportunity, and that's exactly what investors do. They find those opportunities and they invest in them. This is not a perfectly competitive environment with no barriers to entry. So then the next question is, when using a DCF, is can I say with a sufficient degree of certainty that there would have been some profit obtained here? And real estate is different than like a big mining investment, for example, which I know, we see a lot more, for example, right? Where you can sink a bunch of money and you can lose it if there's no gold in the ground, right? That's not the case with property, right? Property has inherent value. So to be profitable, that threshold to reach that sufficient certainty that there was going to be profitability in a property development context is much easier to meet than, for example, mining or something else. And so that's important to appreciate, that threshold for a sufficient degree of certainty that there would have been profitability is much easier to meet in the property development context. And it was certainly met, I would say, here, especially looking at the track record of these investors. And Colombia appears to accept that a DCF valuation is reliable with the correct assumptions, and that's in their rejoinder. Colombia's rejoinder said, it is possible to correct some of the assumptions made by BRG to reach a more reasonable DCF value, which can be verified by appropriate cross-checks, as demonstrated by Dr. Hearn. So they confirm that with the right assumptions, DCF is the right approach. The question, of course, then, is who's got the assumptions right? But by the way, before I get to those assumptions, one important point is the Charlie Hotel, no dispute that wildly successful and profitable. I think that was confirmed by the respondents' experts as well. With respect to the Meritage, DCF is warranted. It was significantly advanced. This is a situation where you pre-sell, right? So the owners have already committed contractually to buy the property, sold out in record time. 152 units, I'm going to build them. I already know who the buyers are. I have contracts with them. They have to buy them. They've put down deposits. My costs are known because I've entered into contracts with my construction contracts. You've reached the point of equilibrium. The banks are giving you money because they know that at this point that it's secure, right? You've reached that point where you know you've sold the units. Everything, with the hotel, et cetera, is basically, you've mapped it out, you know your costs, et cetera, very far advanced. And Colombia, by the way, did not contest any of that evidence. They didn't challenge Mr. Seda's testimony on any of this at the hearing. Luxay, the cabanas were already built. Now, what's the income stream that comes from that? Well, someone has to manage them, right? The owners have bought these cabanas, and they've contracted with the Royal Property Group to manage these cabanas. Hotel, financing is in place. The hotels, they're already booking events. It's 72.5% complete is what the C338, the construction folks will tell you, that it's 72.5% complete when there's an audit done on this project. It was meant to commence operations in January 2017, mere months. This was Meritage, August 2016, January 2017, the hotel was meant to open. They had already hired staff to work at the front desk. Again, none of this is contested because they didn't challenge Mr. Seda's testimony at the hearing on any of this. So let's go to the inputs. What are those inputs? Well, there's three different categories that I'm going to take you through. One is the real estate business. That's basically part of these projects there were houses that were, and apartment units that are being bought and sold. And so you have the revenue side of that and the cost side of that. Then you've got the hospitality business, the hotels, right? How much does it cost to operate, and what are the costs and fees that you're going to earn? And then we'll talk about the risk adjustments. And there's two risk adjustments we'll talk about. We'll talk about the discount rate, and then the properties that are in development, 350 Heights, et cetera, Santa Fe. BRG has taken a further discount on the probability of survival. So let's start with the real estate business. The formula is fairly straightforward. What are your revenues? Let's start with the revenue side of the equation. It's how much do I get to sell? How many square meters am I selling? And what's the sale price per square meter? And I multiply the two, right? Here's my average sellable area, and here's how much I get per square meter. I multiply those two, and that gives me an output of how much I'm going to sell a particular house for example, right? So if I say my house is, we use square feet in the United States, so $1,000 per square foot, you figure out how many square feet you have, and you multiply the two, and that's what your price is. That's a proxy that many folks use for sellable, for revenues on the real estate side of things. And here are, you have two numbers here. The blue column on this chart is based on the business planning documents. So these are Luxay's projections. Their contemporaneous business plans are projecting the sale price per square meter in that blue bar. And then JLL, who I'm sure this tribunal knows is probably the world's leading expert on property, as an industry expert, they've corroborated that by market data in Colombia, in other places. They're saying, if I look at similar units, how much do they sell for per square meter? If I compare that to the Meritage, for example, they're saying, well, actually, in that area, you can get 4.5 million COP per square meter. And so what you see is BRG's assessment in all of those cases, except for Santa Fe, are actually more conservative than JLL's market data in terms of price per square meter. And that's, the equation is as simple as that on the revenue side of things for the real estate business. It's price per square meter times how much land do I get to sell? Or how much property, developed property do I sell? So then you look at the other side of the equation, costs. How much does it cost me to build this thing? And you have construction costs essentially, and then you've got soft costs like marketing and pre-development expenses. And again, you've got the business planning documents, and then you've got market data in terms of costs. I'm sure tribunal members love hearing this when they hear that costs, the cost side of the equation here, is actually not in debate. And that's confirmed by CBRE. They say, according to the claimant's model, construction costs are pretty much aligned with our professional opinion. So Colombia's experts accept that the cost side of the equation here on the real estate business is reasonable. And Dr. Hearn, when I asked him in cross-examination, you agree that the construction costs are in the BRG model are reasonable, correct? And he said, generally speaking, that's the question. And I said, yes. He said, because there are obviously many, many thousands of construction cost assumption. I mean, based on the evidence that I've seen from CBRE, I have no reason to think that they're excessively different from what one would expect. But there's still, I think, a lot of subjectivity into those numbers, but I see no real reason to dispute them. That's right. That's just a typical expert example, but basically what he's saying is, I agree. That he agrees construction costs are reasonable. So to get your damages on the real estate side of things, what do you do? And this is exactly what BRG has done. They take the revenues, they subtract the costs, and that's your damages on the real estate side of things. Obviously then they update that as appropriate. Now, to verify that damage, Dr. Hearn looks at EBITDA margins to compare, is this a reasonable margin that they're getting? And he says, no, they're not reasonable margins. But the examples that he gives, you can see the red part of these graphs are social housing examples. Now, the margins you get in social housing projects are completely different than the kinds of luxury projects that we're selling here, right? And that's because the social housing business is a volume business. Families get subsidies basically to buy these social housing units. And so you have razor thin margins, and basically the business is a volume business. That's what JLL tells us. So when he's looking at EBITDA margins, you can't compare social housing projects to the luxury apartments and cabanas that you saw pictures of at the outset. Those aren't the same types of margins. And then if you look at profit margin comparisons, what did CBRE do? CBRE went and they interviewed people. They did a survey, their own survey. We don't know what the methodology was, but they went and just asked people. They didn't tell us who they asked. It's just random people. It's maybe not random respondents, but they didn't identify the respondents. We can't assess whether or not they're comparable or not. And they just asked them, well, what are roughly your profit margins? And they were asked on cross-examination, did you ask for the underlying data? Or did you take their word for it? And CBRE said, we took their word for it. And you don't list who these people are in your report, do you? And he said, no, not explicitly. So quite frankly, I don't think you can really rely on any of the survey data that you got. They didn't identify the respondents. It's impossible to verify whether the projects are comparable to the claimants. And it's really just survey data that was, very, you saw the cross-examination, and you may recall it's not very reliable. One of the other questions you ask is, well, how quickly can you sell these things? Because the quicker you sell them, the faster you get money, right? And so you have a higher NPV, net present value, because you get money sooner in the bank account. CBRE acknowledges that the Meritage project had record sales. This is in their direct presentation, by the way. CBRE, that's their presentation, the Colombia's presentation. They say, we know that the Meritage at phase 1 had record sales. We were able to verify this. So they're confirming record sales, the Meritage project. But then what they did was they looked at velocity of sales figures from their survey data. Now their survey data, it was really interesting, and I went back and looked at this and I was really surprised. But even if you look at their survey data, they did it for different regions. So they interviewed 4 different projects from Medellin, for example, right? And they said, what's your velocity of sales per month? And one respondent said 2 to 3 units per month. One said 3 to 5. Now we don't know who these people are, so we don't know if they're selling apartments or houses or where in Medellin. But someone said 2 to 3, someone said 3 to 5, someone else said 4 to 15, someone else said 5 to 15, and then someone else said 1.4 to 2. And guess what number CBRE picked for sales velocity for Medellin? 1.4. The lowest of all of the numbers. They didn't take an average, they didn't do anything like that. They just said, oh, sales velocity in Medellin should be about 1.4 per month. And you can see that in the cross-examination. And that's not what the numbers we're seeing here, so it can't be right. But they ignored their own survey data. For Cartagena, same thing happened. They looked at a couple of different developers too. So again, these are not very reliable results. But one of them said, oh, our sales absorption is 15 to 20 per month. And another one said 2 per month. And guess what number they picked in their graph, in their in their report? 2. So they're just taking the numbers that are the most convenient. And they had to say on cross-examination, as I said, this was challenging in connection with the sample we were able to collect. That's the only non-highlighted part on the right side there. So they just said, well, it was challenging that we had to pick something, and they just happened to pick the lowest number in all of the data sets. So it's just not reliable. In terms of the hospitality business, so we've talked about real estate, they build these projects and they sell them. Those are just sales of houses basically, right? And apartment units. But then there's the hospitality side of things. On the hospitality side of things, there are again revenues and costs. And how do you assess revenues? Well, revenues are there, available rooms, and what's called RevPAR. It's a term that's used in the hospitality industry. And basically what RevPAR is the average daily rate times the occupancy rate. So you take, let's say for a hotel, I get $500 a night. And let's say on average, a hotel room is occupied 200 nights a year. So I multiply $500 a night times 200 nights of year of occupancy, and I get my RevPAR. So and if I've got 100 rooms, I multiply all those, and that gives me my revenues on the hospitality side of the business. And the revenue per available room for each of the projects, BRG calculates them here in this slide. This is part of their direct presentation at slide 32. And you can see for the Meritage Hotel, for the Luxe, for Cartagena, for 450 Heights, for Santa Fe, this was what was projected. And you can see as a benchmark, the Charlie Hotel, the revenue per available room was about 509,000 COP per night. Other fees that they got a developer fee. There were certain contractual fees that the Meritage claimants, the Royal Realty as the manager and the developer gets. Those are just contractual development fees that they get. And that's just purely a question of what rights do they have in their contract. And that's reflected in the RR Meritage Company Agreement at 3.08, and we've got the provision there. They get a developer fee, they get a percentage of gross sales, and they get certain additional fees that are paid. And when I asked Dr. Hearn about this, he said, oh, well, I'm not a lawyer, I can't interpret this. But it's all right there, and BRG has assessed how much of these fees would then have accrued to Royal Realty. So on the hospitality side of things, then we go to the other side of the equation. What's the cost? Well, to build and operate a hotel, there are a number of costs. There's operating revenues, operating costs. There's some management and brand fees, and there's profit sharing agreement. And that is all information that BRG has calculated and verified by comparing it to what the market data is, and JLL has assessed what that market data is, and they derive a value per key. So this, in the hotel industry, that's a metric that's often used, value per key. And you can see the blue line on slide 215, that's the value, the average value per key for the claimant's hotels. And you can see that where that ranks in terms of the comparable hotels, sample of hotels that JLL used. So the overall average is $414,000 US, and they for claimants hotels, the average is $388,000 US. So when they're doing this market check, it's a check against the DCF model. They're saying, yeah, it checks out because they're coming in under the against what we think are comparable hotels. They're coming in under that overall average. So it's a reasonability check in terms of the DCF model for revenue, for the value per key from a hospitality industry perspective. So when Dr. Hearn looks at these comparables, what does he do? Well, the way he assesses whether or not these are actually comparable, he goes to booking.com, the website that many of us may have gone to, and he just picks a random night of the year. And he goes, let me see how much each of these hotels cost on that random night that I pick. And so he picked October 28th, 2020, which, by the way, is at the height of the pandemic. And he said, let me check to see if the price for that night, and then I can make an assessment as to whether or not they're comparable to the Meritage and all of these things, these other hotels. And I asked him, so you did this on October 28th, you went to booking.com, is that right? He said, yes. I also used that website. And you forecast out, you put in the date, June 16th. Why did you pick June 16th, out of curiosity? Did you try other dates, or did you just, you just thought June 16th, it's a nice date, let's pick that date? And his answer is pretty much. That's why he picked the date. Not a very scientific approach to picking comparables and deciding or criticizing, I would say, JLL, one of the world's leading hotel experts, as to what is a comparable hotel. I'm not sure that I actually need to do much more on why his approach was flawed. But quite frankly, what he was saying were comparables were just, you heard it, were just not comparable options. You heard from JLL basically saying this demonstrates a complete lack of understanding of the industry. What I do want to spend a bit of time on those, the discount rate, which is at slide 220. And some of the questions were, well, what's captured by the discount rate in this particular case? Does it capture the likelihood that this project might fail? And he said, and he was asked, but I'm talking about the project completely failing. Is that impossible? And when they're talking about the Meritage, he says, and the Luxe, he says that is it taken into account by the discount rate? Mr. Delapiane was asked about that, and he said 100%. That's exactly what it is. It's assessing that for a project that is reasonably likely to succeed, and you know, for the Meritage and Luxe, he's saying that is what the discount rate assesses. It's assessing the risk of the project failing. That's one of the things that's captured by that. And I know the president of the tribunal asked a similar question. How do you capture a risk such as delay in construction, things like that? And that was answered again by the experts. They said in two ways. One is when you project cash flows, because you take into account those kinds of risk delays. That's accounted for when you're projecting, when am I likely to get cash flows? But the second is in the discount rate, because the beta parameter for the real estate industry, that's one of the things that's incorporated into the discount rate. So things like delays of construction work, that is all captured by the discount rate. If we go to 223, Dr. Hearn's discount rate and his assumptions are just not reasonable in our view. And why is that? Well, the discount rate, as this tribunal will know, is driven partly by the cost of debt and the cost of equity, so the overall weighted cost of capital. And the cost of debt that he uses for his discount rate is the cost of construction loans. But when you're operating a hotel, that's not the right discount rate to use, because the cost of construction, the loans for construction, is just a different metric than when you're actually operating a hotel. Because at that point, you have a cash flows, right? So the rate at which you can borrow for an operating hotel or for a management of houses or aparta suites is totally different than the cost of debt for just construction loans. So his cost of debt is not a reasonable proxy for what should be used for an investment like this. And he overestimates the market risk premium by calculating the arithmetic rather than the industry-preferred geometric average. And BRG has talked about that. And Damodaran, who I've never actually met, but have said his name more times than I can count, prefers the industry-preferred geometric average. And if there's one thing I've learned in arguing damages is when Damodaran says it, it's something you should look at closely, and we would urge the tribunal to do that in this particular instance. Of course, you have to apply it appropriately, but in this particular instance, the industry-preferred geometric average, we would say, is preferred. And in assessing country risk, he uses the Colombia peso-denominated issuances, which are thinly traded and just not reliable because they're thinly traded to assess country risk. When something is not traded robustly, you shouldn't use that as a proxy for assessing country risk, whereas BRG uses the EMBI calculated by JP Morgan, which is based on US dollar denominated issuances, which are much more widely traded to assess country risk. And then, as I said, for these early stage projects, what they do based on input from JLL on the probability of survival, JLL, what they did was they said, when projects are started, what is the probability at these early stages that they fail? So let's add an additional, taking a conservative approach, what is the probability of success for projects that aren't as advanced as a Luxe or a Meritage, where you've already sold units, it's, the construction contract, you've de-risked it all the way. And there, they've applied a multiplier of 77% for the development projects and 61% for the expansion projects, to give you that, taking into account that additional risk. Now, members of the tribunal, it is 1 o'clock. Maybe let me say one more thing, and then I think I have about 15 minutes left, but I'm sure I'll be corrected if I'm wrong. But I can do that last bit after the break, if that makes sense. But let me end on this slide 227 before I suggest we take a break, which is based on all of those parameters that I've just discussed. You put that into the model, and ultimately what BRG comes up with is damages that align with this table. So $64 million for the Meritage, $44 million for Luxe, for a total of $108 million for those two projects. And then the projects in development, an additional $80.5 million. With pre-award interest, that's how you get the $255 million. Actually, I lied. One more thing I do want to say, which is on pre-award interest. I think at the very least, something that needs to be or should be considered generally by tribunals in general, and I hope this tribunal in particular, it is a disincentive for respondents to pay when you use a pre-award interest rate that is lower than their own cost of capital. So when a state can borrow whatever they borrow money at, right? And here you have on slide 229, their cost of debt. When you use an interest rate that is lower than that, then they have a disincentive to pay us because this is the cheapest money that they can get, right? Not paying us is cheaper than borrowing money from someone else. So what we suggest is using a cost of debt, the claimant's cost of debt, as an appropriate proxy for pre-award interest, because that's how much we have to borrow at, which is about 5%, and that number is above Colombia's cost of debt, which I think incentivizes things appropriately. It doesn't disincentivize them from paying this particular award. The last thing that I would spend my last 10 to 15 minutes on is the essential security defense. We will not likely cover the jurisdiction slides today. We may come back to them tomorrow in rebuttal. But members of the tribunal, it may make sense to take our lunch break before I come back after lunch to address you on essential security.
Thank you, Mr. President. It's interesting that we hear that the jurisdiction slide will not be addressed, but may be addressed tomorrow in rebuttal. I do have a due process issue with this because there's a great number of slides that were just passed over that we didn't hear about. This is not the way that we've done things. So it's a full new submission, and I do have an issue with Mr. Mulu just going through or not going through them and just say, I'm going to come back to you tomorrow in rebuttal, if he has not addressed it. So either he does or he doesn't. And I have a problem with essentially putting all of these slides as a submission and not address them and just keep them in a safe place for tomorrow as a rebuttal. That is an issue in terms of due process, I'm afraid.
Yes, Mr.
May I,
Mayor.
Mr. President? We were expecting not just to have these slides, but possibly other slides, if we may burden the tribunal with additional slides. But for rebuttal, I don't think there was anything in the procedural order not allowing us to rely on slides. Obviously, when you talk about jurisdictional issues, those are objections on jurisdiction that have been raised by the respondent. So I think some of those may be more appropriately dealt in rebuttal. You know, we're in the tribunal's hands, but I don't think we should be prevented from using slides in rebuttal tomorrow.
Just to be clear, if I may, thank you. The rebuttal is expected to address what we will have argued. So if they're keeping under their sleeve slides that they will address tomorrow, which may or may not be in response to our briefing today, that is inappropriate. Either it's in rebuttal, precisely of what we will have said, or it's not, and then they cannot do that. The question is not about having slides or not having slides. By the way, we are at the disadvantage here because they will have all of evening to prepare for the rebuttal. We will have very short time after the rebuttal. So there is an imbalance there. So this even further aggravated by the fact that they are keeping slides just in case, and they may address more than what we will have said as a rebuttal. So rebuttal is rebuttal.
Well,
Yeah. Yes, we agree. Rebuttal, we will not, if they don't address jurisdiction, for example, at all, we would not address jurisdiction either. So I'm not suggesting that we would address arguments that are not in response to arguments that they raise tomorrow. This afternoon, rather. And I'm not sure I understand the disadvantage because we've now given our full openings and they have more time than we do to respond. I'm not sure I understand that argument, but I can assure the tribunal members that we will not deal with anything tomorrow that has not been raised this afternoon.
To be very clear, this is a submission which has not been put fully before the tribunal. So I do take issue with all of the slides that we have not seen and are there that the tribunal may or may not look at in its own time. But it's an imbalance in the sense that we have tried really to address it. We asked for more than 3 hours. We're giving only 3 hours. In those 3 hours, we will address a number of things, but there's so much in this submission that they have not even gone through, that the tribunal will now have in front of it for deliberation purposes, and it will not have our view on those slides because it's way more than what you would expect for 3 hours. That's point one. Point two, the imbalance that I discussed about rebuttal is that they will have all evening, all afternoon, all evening to prepare for the rebuttal of what they will hear this afternoon from our side, whereas for our rebuttal of 30 minutes tomorrow, we will have, for now, about 15 minutes to listen to what they say and come back and discuss and argue rebuttal. So the imbalance is between what's going to happen tonight and the 15 minutes we'll have tomorrow for that. The other imbalance where I'm talking about is the fact that this is a full submission with a lot of slides that have not been explained and the tribunal has before it, which is much more than what we will have the opportunity to explain to the tribunal, because there's a lot here that you heard, and we are only in a position in the little that we have, which is 3 hours, where we are trying to address things, but we cannot address everything. And so this is the issue of the imbalance on the slides, which is a different issue of the rebuttal.
okay.
I hope this clarifies.
Let's go step by step. You said you need 15 more minutes to deal with the essential security exception.
Yes, by our calculation, that's about what we have. I may be wrong, and that's about how long I think I'll be.
Okay, so how much more time do you have?
About 15 minutes.
About 15 minutes.
Yeah, Sarah will correct me. Ms. Marzal will correct me.
I have 7.5, but I mean, if this is
I
what
think
have.
we had, I mean, we're in the tribunal's hands. I think I have about 15 minutes more of submissions, if that is.
On
of
the
assistance.
security.
Correct.
Issue, not on jurisdiction.
Not on jurisdiction. And we made the decision at the break that if we were pushed for time, which I'm in a bit of between a rock and a hard place, which is I want to obviously be respectful for the time limit, which is 3 hours, and I think what makes most sense is for me to address you on essential security. And if there was one thing that we would submit that we will just deal with, if it's raised by, to the extent it's raised this afternoon on rebuttal, is the jurisdictional issues.
Okay, I think we would prefer to give you some more minutes also to deal with jurisdictions so that we cover all what is in the file here. And of course, you will be granted some more time as well. And possibly also consider that, I mean, this program was set up by you, so, but when I look at it, the break is a bit too short indeed in the morning, next morning. So we could consider prolonging it to at least half an hour, or to 11. So, and then we start with the respondent's rebuttal at 11. That would lead us to 11:30, then we will have a short break, and then we have the questions and answer. I think this would be fair. I mean, it was your program, but
Yes.
looking at it, I think the respondent has a point here.
We're fine with giving them a longer break, Mr.
Yeah.
President. That's fine with us.
Okay, and so this afternoon you will deal both with the essential security exception and jurisdiction very shortly?
Yes, I think if we're in that position, I think. So I think then maybe we get, instead of 15 minutes, we do 30 minutes, and we
Okay.
can deal with all
And
of it.
obviously you get the same 15 minutes more.
Well, there's a discrepancy between the understanding from the claimant about how much they have, which is 15, and the ICSID calculation, which I think is what binds everyone, which is 7.5. So if they have 7.5 plus the rest, then we should have the equivalent.
Okay.
We're fine with,
Okay.
yes.
But it would be helpful to have the account at when we come back, so that we know how much time more we have.
Well, I think that's already set, 7.5.
7.5. If they have 30 minutes, then we have the rest. 30 minus 7.5.
Yeah.
Thank you.
Very good. So we will have a break and resume at 2:15, is that all right?